So there is a federal law that makes it a crime for public officials to abuse their authority and violate people's constitutional rights. It's been around in one form or another since the Reconstruction era, when Congress first confronted the reality that state actors, especially in the postbellum South, were using government power to terrorize rather than protect. That law, now codified as 18 U.S.C. Section 242, was meant to give the federal government a clear tool to intervene when state officials turned the force of law into an instrument of oppression. But honestly, that tool is broken, and has been for 80 years. The reason lies in a 1945 Supreme Court decision called Screws v. United States. In that case, the court, they kind of rewrote the statute in a way Congress never intended, requiring prosecutors to prove not only that an official acted intentionally and harmed someone, but also that they specifically intended to violate a right they knew to be protected under federal law. This added mental requirement, subjective legal awareness, has made the statute nearly impossible to enforce. Prosecutors must now do more than prove abuse of power. They have to prove what an official believed legally at the very moment of misconduct. Did the officer understand the constitutional doctrine he was violating? Did the jailer know the exact federal right being infringed? That evidentiary burden is not just steep, it is structurally flawed. It turns a criminal investigation into a psychological inquiry, and it allows deliberate, harmful, unconstitutional acts to go unpunished simply because the actor can plausibly deny legal awareness. This is not what Congress intended. The original design of Section 242 was simple but powerful. If a person used state authority, willfully targeted another, and in doing so deprived them of a right protected by the Constitution or federal law, then a crime had occurred. The standard was high, but it was about conduct, not cognition. Screws changed that. It transformed a structural safeguard of liberty into a riddle about mental states. It made the law less about accountability and more about plausible deniability. And in doing so, it gutted the one federal criminal statute designed to address official abuses of power, especially in places where local authorities refuse to hold their own accountable. This isn't a theoretical problem. When police beat an unarmed person, when jailers deny due process, when public officials target individuals for their race or views, Section 242 is supposed to provide a remedy. Civil lawsuits under 42 U.S.C. Section 1983 allow for private damages, but Section 242 allows the federal government itself to prosecute egregious abuses that violate the public trust. And yet, because of Screws, that power is largely unusable. Even in clear-cut cases of misconduct, the Justice Department often cannot prosecute unless it can prove that the official not only acted intentionally, but did so with a conscious legal aim to violate a federally recognized right. Absent that, there is no crime, even if the victim is left battered, silenced, or dead. The consequences are profound. The federal government cannot enforce the Constitution where it matters most, in direct, willful assaults on civil rights carried out under the guise of law. Instead of being a sword for public protection, Section 242 has become a shield for official misconduct. The court should fix this. It really does have the power to do so. And it has done so before, when old decisions misinterpreted statutes, created unworkable standards, or abandoned clear congressional purposes. In recent years, the court has overturned precedents, like Janus, Kimball, and Dobbs, when they proved egregiously wrong, legally incoherent, and untethered from the original meaning of the law. Screws meets that test. It was a doctrinal mistake. It misread the statute's plain text. It distorted its constitutional role. And honestly, no meaningful reliance interests justify keeping it intact. Overruling Screws would not create new rights. Instead, it would restore the enforcement of existing ones. It would reaffirm that when public officials deliberately use their power to suppress, harm, or punish in violation of the Constitution, they can and should be held criminally accountable, regardless of whether they can name the clause they were violating. Federal civil rights law should not be a trivia contest about doctrine. It should be a backstop against lawless government. Congress wrote Section 242 to ensure that when local power becomes abusive, the federal government can act, not arbitrarily but clearly and justly. Screws undermined that, and the consequences have echoed across decades of impunity and injustice. It is time to restore the statute's original meaning. It is time to reaffirm that in the United States, no one, not even in uniform, not even under color of law, stands above the Constitution.